How is child support determined? How long do I have to pay it? How can it be modified? These are the questions we're going to talk about today. I'm Michael Miller. I'm a partner at Cole Miller, PLLC. We are a family law firm located in Vienna, Virginia, serving primarily in the Northern Virginia area. I analyze problems and find affordable solutions for families and their family law needs. Now, this is our fifth and final installment of our what I call the 5 topics of divorce. We've covered property and debt, which are the first 2 topics. We did that in one video because they're governed both by Virginia Code 20-107.3. In our third video of the series, we talked about spousal support. And we just recently completed our discussion on custody visitation. And now we're going to talk about child support. And as I said in the introduction, we do child support last because it is dependent upon the custody visitation schedule to know whether, where the children are living and how much time with each parent, because that gets factored into the formula. And we also have to know what the spousal support is because that can affect the parent's income. So if a parent starts off with $100,000 and the other parent is $0 and they pay $30,000 of spousal support, now it's a 70-30 ratio as to how they split the child support obligation. So lots of things going on here. Again, this is a topic that is applicable to non-married people as well as married people, and it's applicable in both the circuit court as well as the juvenile domestic relations district court. And the thing we start with here is the statutory guideline amount of support is presumed to be correct. However, once the judge does the guideline determination, then the parties are given an opportunity to present evidence and argument as to why the guideline amount is unjust or inappropriate. If the judge believes it to be unjust or inappropriate, then the judge makes written findings to that end and then allows the parties to proceed to deviate from the guideline amount. We'll talk about that in some more detail here in a minute. So the guideline amount, the statutory factors we've been talking about can be found at Virginia Code 20-108.2, which is unusual, or maybe it's not unusual because we did the same thing with spousal support comes in the statute prior to property division, but they're determined in the reverse order. Likewise, the guideline amount is presumed correct, but that statute comes after the deviation factors. And if you look at that statute, it lays out a formula, but it also has a table there. And what the formula does is once you go through the table, if you run off the end of the table, then you apply the formula to come up with the guideline amount of support at that point. The thing about the table is, and about the formula, is if we start with, let's say the 2 parents' combined income together is $1,000, then for one child, the support obligation would be $187. And then that $187 gets split between the parents in proportion to their income. So if it was one parent makes $200 and the other one makes $800, then it's a 20-80 split. So that's how the $187 is shared between the parents. Then we look at the custody visitation schedule. If the child lives with the parent with 80% of the income, then the 20% parent pays the 80% parent, or vice versa. If the child lives with the 20% parent, then the 80% parent pays. So that's why we have to know, who has the child to know which way the child support flows. Now, 2 children is not twice the one child amount. The increase is at a decreasing rate. So for 2 children, it's $285. So we went from $187 to $285. Likewise, if income goes from $1,000 total to $1,500 total, it's a 50% increase of income, but it's not a 50% increase of child support. So for one child, it goes from $187, goes up to $269. So a little bit short of the 1/2 there. When we're talking about income, the statute defines that is that for purposes of this section, gross income means all income from all sources shall include, but is not limited to, income from salaries, wages, commissions, royalties, bonuses, dividends, severance pay, pensions, interest, trust income, annuities, capital gains, Social Security benefits, except as listed below, Workers' compensation benefits, unemployment insurance and benefits, disability insurance, veterans benefits, spousal support, rental income, gifts, prizes, and awards. Almost a broader definition of income than what the IRS uses to tax you. Now, one thing about this is if a parent's gross income includes disability insurance benefits and there's any amount that's also paid to the child, then the child's portion gets added in, but then it gets credited back out on the other side. There is some relief for the parent who may be paying support is with regard to gross income, is you can deduct reasonable business expenses. And that's for persons with self-employment, partnership, or closely held business income. In that case, then gross income also does not include benefits from public assistance or social services as defined by the statute, federal supplemental security, income benefits, or child support received from other persons. So if you have children with different parents and the one parent pays child support, that does not count as income to the recipient for purposes of determining child support with the other parent. And the thing there that frequently comes up is that people have rental properties, so they rent the townhouse or whatever for $1,200 a month. They pay an $1,100 a month mortgage. Do they have $1,200 of income for purposes of child support, or can they deduct the mortgage payment there to come out with the $100? And I think the kind of the general idea when you look at this, closely held partnerships and so forth is on paper, the money may be there, but is the cash actually coming in that's available to the parent that they could then pay support with it? For people who fall behind and get in arrears on their child support, there is some relief here too, that income does not include income from secondary employment where you go out and get that secondary employment in order to pay off some of the arrearages. So, that was a problem in the past is people find themselves in arrears on their child support. They go out and get a second job, so they have additional income to try and pay those arrears down. And then in the process end up, working 24/7 and then have that added income added back into a modification, and they end up paying more current child support, and they don't have the money there now to pay off the arrearages. So there's some relief there for that second source of income. Now, child support is not only based on income, it can also be adjusted by the time, as we've talked about, and can also be adjusted by the cost of health insurance. So if one of the parents maintains health insurance for the child, the cost of the child's health insurance is added into the total need. So you start with the parent's income, as we talked about there. If the parents' combined income is $1,000, that's the base need. Then on top of that goes the cost of of health insurance. On top of that goes work-related daycare. So those are the three adjustments then that go in to find the total financial obligation to be shared between the parents. What you have to do there is see if your employer will break down the cost of your health insurance premiums. Find out, what the delta is between like being self-insured or self and child. It's the additional payment for the and child then that gets added in. It's not the entire insurance premium obligation. And then the next thing we look at then is any kind of child care cost, but their child care costs due to employment of the custodial parent. So if, the one parent gets remarried and under their new relationship with their new spouse, they're a stay-at-home parent, you cannot go back to the ex and say, we think it's a good idea, for little Johnny to be in daycare, even though I'm home all day long and we want you to pick up, half or more of that tab for that. The daycare has to be, added in or has to be work related or due to employment. And part of this too is that you can look at if you take and impute income to a parent that they should be working, then you can also reduce that imputed income by the cost of daycare they would otherwise have to get if there's other children then that have to be put into the daycare. The provision here is it is quality daycare, so you don't have to put your child in the cheapest available place to supervise it. If a parent wants to, as part of the responding to the request to share the cost of that, they can seek verification as to what the costs are. And then they can also ask to show the tax savings and have the court roll in the tax consequences of providing that daycare if there's care for dependent children or something like that. The other thing the court can look at with regard to one parent saying, oh, well, I need daycare, is the willingness and ability of the non-custodial parent to provide care. And so the one parent says, well, I have to go to work. We need to put the child in child care. The other parent can say, well, I know it's not my visitation time, but I'm willing to, pick up at 8 o'clock in the morning when you go to work, and I'll drop off at 3 o'clock at night when you get home from work. Therefore, I am available and I'm willing to provide daycare, and so you won't need daycare. So that's one way to try to save the costs on that. Then, apart from daycare, or apart from child support, so we've got the child support, the guideline amount based on income, health insurance, and daycare. But that's not the sole financial obligation that a parent can have, because we also have to look at the provision to share reasonable and necessary medical expenses that are not covered by insurance. And so you look there of, are there co-pays? Are there, elective surgeries or cosmetic surgeries or something like that insurance doesn't cover? Then that would be shared separately. Now, for something like orthodontics or braces, where it's $100 a month for the next 3 years, that can be built into the formula, or you can also have it done in order to be done on a as needed or as occurred basis, so that if a child goes in and gets a prescription medicine and it's not covered by insurance, then the parents would share that one-time cost. The thing here is it has to be reasonable and necessary. So the parent that runs out and finds the most expensive orthodontist or, something like that, where the cost varies, they would then have to show that the cost of the treatment that they're asking to share is reasonable. They also have to show that it's necessary. So again, you look at, is, orthodontics necessary, or is it a cosmetic matter? Different parents take different views on that and choose whether or not they want to try to agree to share that or try not to share that. From what I've seen, though, too, is if one parent says, I want to get this treatment done, will you share the cost? The other parent may not want to share the cost, but they are willing to allow the treatment to proceed so long as they don't have to pay for it. So that's kind of a compromise there as to how important you think it is as to how strongly you want to pursue having the other parent share it. And then that's where there's different variations then in the statute that come in that talk about, how do you address the sole custody, the split custody, the shared custody, and so forth. And all that is under Virginia Code 20-108.2. So once you've gone through all that, the judge has taken the evidence on that, determined the parents' incomes, and for this initial guideline determination, you take the parents as you find them. So there may be an argument of imputation of income, but on child support, it comes later. For purposes of spousal support, it comes up front as part of the initial determination. There is no guideline or presumptively correct amount of spousal support, so the income and the expenses and the imputed income all get built into that. If that's already been done, then you can carry those numbers over into child support, but as I said, if you have unmarried persons, they're trying to do child support, take the parties as you find them, determine the guideline amount, and then make present your evidence and argument as to why the guideline amount is unjust or inappropriate, get the judge to agree with that, make the written findings. Then you can come into 20-108.1 and start working through the deviation factors. Deviation factor is Again, there are 15 of those, as we've seen previously. The last one is any other factors necessary to consider the equities of the parents and the children. Most of these I'll go through real quick, but the one here I will focus on is factor number 3. So factor 1 is the actual monetary support of other family members or former family members, arrangements regarding custody of the children, including cost of visitation travel. That comes up where if a parent says, well, I want to relocate, or if a military member is forced to relocate, and now they're spending thousands of dollars on air travel, you can ask the judge to reduce the guideline amount of support to take into consideration the cost of the air travel and stuff like that that's required to maintain the relationship with the child. Factor 3 is the imputed income of a party. And this is where you look at, it's a party who is voluntarily unemployed or voluntarily underemployed, provided the income may not be imputed to a custodial parent when the child's not in school and child care services are not available, or the cost is not included in the computation of the guideline amount. Also, there has to be a consideration and of the good faith and reasonableness of employment decisions by that party, including whether to complete an educational or vocational program likely to maintain or increase the parent's earning potential. So here, a parent may say, I'm not employed because I'm finishing my degree or certificate program. Maybe no question they could be working, but it would make sense for them to have a short term of unemployment with the expectation there's a long-term payoff and increased income from that. The factor 4 we look at is any child care cost incurred on behalf of a child due to attendance of the custodial parent to the educational or vocational program. Factor 5, we look at the debts of either party arising for the benefit of the child. And some of these you kind of see, the child that may be involved in the travel sports team, or, gifted musicians or something like that. Or they, going out having to purchase, expensive sports equipment, expensive musical instruments, something like that, plus the cost of getting the child to their competitions, their performances, and things like that. Court can also look at any cost of providing any cost of providing life insurance, educational expenses, or other court-ordered direct payments for the benefit of the child. Look at any kind of extraordinary capital gains resulting from the sale of the marital abode, the independent financial resources of the child or children, standard of living for the child or children established during the marriage. And this is kind of where we come in here. For instance, like especially the highly compensated athletes, if you do the guideline amount, it may come out to be, the parent owes $25,000 a month in child support, but at some point, you've got the children's cereal, clothes, meals, transportation, everything covered, and it's like, okay, so what's the other, $20,000-$30,000 of support for? At some point, it starts to look more like a wealth transfer from one parent to the other parent rather than a support to meet the child's needs. Then you look at the earning capacity, obligations, financial resources, and special needs of each parent. Any kind of provisions made with regard to the division of marital property. So again, in a divorce context, that's done up front. So that can be considered as part of the child support, which is done last. Tax consequences, factor 13. Any kind of written agreement or stipulation or consent order is factor 14. And as I said, there's the factor 15, kind of the catch-all. The court does have the power to take any existing life insurance in order that the child be designated as a beneficiary of that, so that in the event of a parent's death, there's alternate financial resources available for the child's future. Court can also, in this instance, look at requiring one parent or the other to sign off on tax forms to transfer the dependency exemption or any kind of tax benefits back and forth. Again, it kind of makes sense that if you have one parent that's paying little or nothing in taxes, claiming that child provides little tax benefit to them, whereas the more highly compensated parent on the other side may get substantial benefit from being able to claim the child. And so it would make sense to move the child over to provide the greatest tax savings. There's kind of a notion that the greater the tax savings, now the more money the family has, and that the added money will trickle down then for the benefit of the child. So whether it does or doesn't sometimes remains to be seen. For both custody visitation as well as for child support, the court can always come back and modify that. So Virginia Code 20-108 provides that upon petition of either party or upon the court's own motion. So if you're there for something else, you may precipitate an instance where the judge says, hold on a second, on the judge's motion, let's go back and modify some of this stuff. Also, any probation officer of the Department of Social Services can intervene and have a recalculation done at that part. One thing to look here too is intentionally withholding visitation of the child can constitute the material change of circumstances that's necessary to come back in and modify the children's arrangements. And in particular, if the guideline amount of support is based on a shared custody basis, assuming that the child's going to spend 1/3 or 1/2 of the time with the other parent, but that other parent doesn't follow through with that time, that can constitute a material change that you can then come back and say, Judge, we were just here a year ago. The other parent made this argument. It was going to be a 50-50 split. But as soon as that order was entered, they never came to get the child. The child hasn't been there half the time. The child's at my house constantly. And so the child support should be based on a sole calculation, not the shared calculation. And you can do that. The other thing here, too, is in 2108 is a provision for members of the armed forces. If they're deployed, they can have consideration of their deployment in light of that. So, again, as we saw with the child support matters, we have focused on the substantive issues of determining support, but there's a whole jurisdictional process out there as to, are you even in the right court, and how do you find a court to either modify, enforce, or establish support orders. And for that's the Uniform Interstate Family Support Act. And I have a whole couple presentations planned to discuss uniform acts and generally, and the Uniform Child Custody Jurisdiction Enforcement Act that pertains to custody visitation, and the Uniform Interstate Family Support Act as pertains to support. So we'll deal with those later, but I think we've covered enough today to establish our groundwork on the 5 issues we need to do to conclude a divorce.